this is Andrea Kane, and I am here with you for HIT 421, where we are talking about legal and release of information. We are still on week 4, but we've moved on to chapter 7. So if you want to follow along, open your book to page 121. This chapter typically gets kind of skimmed over in our program. There's not a lot of information that sometimes is necessary. However, I think it's really important for us to look at the elements of a valid contract, understand the differences between a for-profit and not-for-profit corporation, learn about some of the information that has to do with the board of directors or the hospital board, and then especially about the patient-physician relationship as a contract. So those are the things that I'm going to focus on here. And I think you have minimal questions on this chapter in your quiz. Again, it's really just to make you aware of some of the information. So if you are not familiar, this is a definition about corporation. What is a corporation? It's an artificial being that's created under the authority of state statute. Notice that, state. So each state can define articles of incorporation, what they require, and all of that. However, they have to do that considering the IRS's requirements. And you can look at your book for some more information on this. I'm not going to get too deeply into it because there's a lot that we could go into, but not necessarily applicable for what we're studying for. There are different types of partnerships, and you might hear of joint ventures sometimes between healthcare organizations and physician groups and others. And then there's sole proprietorships. Corporations are a legally separate entity. Their owners are shielded usually from personal liability, and taxes, they're taxed separately from the owners. So that's things to be aware of. So liability protections offered by a corporation to its owners are not absolute. That's one of the important things. That even though there are some liability protections, they are not absolute. There's such a thing as called piercing the corporate veil. The protections can be pierced if the corporation is used by its owners to commit fraud or other crimes. Or they may be directly liable for the bad acts. And why do you need to know this? Well, we talked about fraud and abuse. If a hospital is owned by individuals in this corporation or owned by a corporation and it commits fraud or other crimes, the owners can be held liable through this concept of piercing the corporate veil. Otherwise, typically, the owners are not liable and it's just the corporation that is. And I'm not going to go through this because, again, it's not something we're going to cover. Corporations can be privately held or they can be publicly held. Privately held can include owned by a community, owned by the county, owned by individuals, those types of things. Publicly held is typically where stocks are sold, shares, and you have shareholders. This would be some of the large healthcare systems that are for-profit are publicly held, and you can actually invest in those, and they'll sometimes give you a return on your money. So for-profit income's distributed to shareholders and others for their private gain. Not-for-profit means that the income has to be used for the corporation's purposes. It's not distributed to individuals for private gain. That's the difference. Both need to make a profit. Let me come back to this and emphasize this. For-profit and not-for-profit hospitals have to make a profit in order to stay in business. They have to do it. For-profit simply means that any income they get, it goes to all the shareholders. Not-for-profit means they take the profit, they put it back into the business to improve the business. Individuals don't benefit from the profit if they're not for profit. If they're for profit, individuals can benefit from that profit. Not-for-profit, they have several rules. In fact, down here it says they're determined by state corporation laws, because remember, each state has their own corporation laws. Yes, they follow the IRS rules when it comes to taxes, but how the incorporation works is up to the state, and that varies. But most not-for-profit corporations need to be able to demonstrate some specific social or beneficial purposes. They have to pay reasonable salaries. They will get preferred tax treatments if they also are formed for a charitable purpose that benefits the public or community. And this is where hospitals, not-for-profit hospitals, have to meet certain requirements in order to keep their not-for-profit status. They have to be able to show that community benefit every year when they turn in their information to the federal government. This has to do with the IRS. And so, as I was talking about, they require hospitals to meet criteria in order to be tax exempt. I'm not really going to go into all of these. They're there for you to read through, and also in your book. Let's see here. Page 124 has quite a bit of this. So I would look there if you want to go deeper. And then this continues on. And then it talks about the community benefit standard. And that's also on page 124. There have been challenges to tax exempt status. And going back to the IRS, one of the things is you can't get politically involved. So not-for-profit hospitals have to stay out of politics in order to keep their not-for-profit tax exempt status. That's just sort of an aside. And so there have been some challenges to tax exempt status for not-for-profit hospitals because there's a lot of tax money that isn't collected because of them being exempt. So there have been some arguments that that should change, and people have wanted to know, is there aggressive or inflated billing practices happening in not-for-profit hospitals, and how much charity care are they providing? The governing board of a corporation is the ultimate legal authority of that corporation. So that's why you hear about the governing body or governing board of a hospital making decisions and that sort of thing, that they're above the CEO, they're above the medical staff. It's because they are the ultimate legal authority of that corporation. They are governed by bylaws, and we've already talked about bylaws, rules, and regulations, I think, a little bit. But bylaws are these internal rules that describe the governing board's powers and duties. The makeup of the governing body is determined by the bylaws. So it covers things like number and type of members, terms of service, qualifications, duties, numbers of meetings, methods for making decision, and compensation. So what are some typical hospital governing board duties? They're listed here. And you can see why this is important for you to know, especially if you end up working in a hospital. Typical committees of a hospital governing board. Again, this is very helpful for you to see. A governing board has a fiduciary duty. That means that loyalty and responsibility. It's their responsibility to take care of and to make sure that the corporation is stable and will go into the future and will continue serving the community. In not-for-profit corporations. In for-profit corporations, the fiduciary duty is more profit-based because, again, the whole point of that corporation, if it's for-profit, is to make sure that individuals who invested in the corporation do financially profit. So there's a few differences there. So loyalty means that they put the corporation's interests ahead of their own personal interests. If you've ever heard of conflict of interest, that means that they need to make sure that that's disclosed and that they stay out of any situations that involve a conflict of interest. In terms of responsibility, they have to act with due care in exercising their duties. They need to make sure that they do due diligence, which is making sure that what they're doing is appropriate. They are generally protected, not always, but generally from personal liability if they fulfill their duties of loyalty and responsibility. However, personal liability may result if they breach that fiduciary duty. So keep this in mind. The Ultra Vires Act, that is the governing board or corporate executive decision making that goes beyond the express or implied powers of the corporation. So if they go beyond ultra vires, those acts are void and they can be held personally liable, especially if there was a financial loss that resulted from their act of going beyond. There are corporate mergers, acquisitions, consolidations. I'm not going to talk about those, but these definitions are here for you. Contracts. A contract is a legally enforceable oral or written agreement. That's a contract. Notice that it's not just written, it can be verbal. So you have to be really careful if you promise someone something. That can be construed as a contract that is legally enforceable. They can be expressed or implied. And parties to a contract must be competent mentally and legally. They have to be legally competent in that they're over the age of majority or they meet that of an emancipated minor. And the individual that is part of this contract has to be mentally competent, mentally capable of understanding what they're doing and what they're agreeing to. So make sure that you know these. This is an important slide. So a contract describes an agreement between two or more persons or entities, and the elements of a contract are a valid offer, an acceptance of the offer, and a consideration. What are each one going to receive for performing the obligations in the contract? So you have the valid offer, that's a promise to do or not do something, and the other party agrees to do or not do something. Then you have acceptance, which means, okay, they agree this is what we're going to do. I mean, there's clear acceptance, which is typically signing the contract. That's the acceptance. If you sign it, that's it. Consideration is what will each party get out of this? I mean, what are they trying to get out of this? Breach of contract is where the terms, one or more of the terms, have been violated by one or more parties. And this is where it starts getting into the legal aspect of things. Breaching a contract leaves you open to litigation, and typically it is tort-based. Okay? Remember we talked about civil versus criminal. This is all civil. Breach of contract lawsuits have to be filed within the applicable statute of limitations. We talked about that, and that's going to be based on your state or based on the contract if it's shorter than what the state permits. There are some defenses for non-performance of a contract. They include fraud, mistake of fact, duress, illegality, impossibility. But again, if you're saying that the non-performance of a contract was because you committed fraud, I think you're going to be in deeper water than what you planned on. Mistake of fact, if both relied on a mistake. If there was a mistake in the contract, neither side saw it, and that turned out to be what it was, then that's a defense for not performing. And then it talks about duress, illegality, and possibility, and those are just exactly what they sound like. And this is on page 128 in your book, if you're looking at book pages. So I'm not going to go through here and talk about illegality, but it just, obviously, if it's illegal, it was something that's done inappropriately or shouldn't have been done against the law. Remedies. This is designed to make the injured party whole and include monetary damages, specific performance. It can also be arbitration, where a neutral party resolves the dispute rather than taking it to court. So, for instance, if you have a breach of contract, you can sit down and agree to monetary damages. It's sort of like a settlement without going to court. Or you can agree to specific performance, meaning that whoever breached the contract is going to honor its contractual obligations. Or you can have arbitration. Hold harmless indemnification clauses. I'm not going to get into those. If you end up writing contracts, you will need to understand all of this. I did write contracts for a short period of time, off and on throughout my career, for things like release of information services or transcription services or contract coding services, that sort of thing. Thankfully, most of the organizations I worked for had a standard contract that we used, but sometimes you have to go through and look at the verbiage and brush it up. But since that's not something you're probably going to do at this point or anytime near in the future, I'm going to skip through. Warranties. This is representations that induce a party to enter into a contract. They guarantee what's going to happen related to the quality of goods or services. They can be express or implied. They may also be disclaimed, meaning that they say there are no warranties. When you look at health information technology contracts, they're very significant because healthcare organizations continue to adopt EHRs and they're more and more complex. You have to watch out for boilerplate language, which are standard terms, often in vendor written terms that favor the HIT vendor. There's something called learned intermediary. This is a defense doctrine that companies have a duty to warn physicians directly about potential adverse effects of their products, and physicians must interpret this information and advise patients appropriately as learned intermediaries. So let's take an example of maybe, I don't know if you want to talk about a heart stent or you want to talk about a joint implant, something like that. The companies that provide those products have a duty to warn the physicians about potential adverse effects because no product is perfect. Then the physicians, as the learned intermediary, are responsible for interpreting the information and then advising their patients so that patients understand the potential adverse effects of utilizing those products. That's what that is. And it's a defense doctrine that the companies have used successfully when patients have sued. Patient-physician relationship is a form of contract. The physician is agreeing to provide services in exchange for payment. This contract can be express or implied. When you think about it, if someone shows up to the ED, they're implying they want treatment because they're coming to a place that provides health care. They're seeking health care. That is implied. Express is when they sign the consent to treat, or they say, I want to be treated. Obligation to treat does not arise until there is a physician-patient relationship. A promise to a patient about the certainty of an outcome, that's a warranty, may lead to a breach of contract lawsuit. Because remember, warranty is guaranteeing the quality of a product or service. Termination of a physician-patient relationship can occur by action of either party. The patient can stop treatment, or they can pass away. Both parties can agree to end the relationship. A patient can be dismissed by the physician, or they can choose to dismiss or fire the physician. That's where basically the patient never comes back to the physician, or they say, I want a second opinion and I'm no longer going to seek treatment from you. That's where a physician would send a letter to a patient to let them know that they're releasing them from their care because either they haven't come in or they haven't followed instructions, those types of things. A physician can avoid claims of abandonment by avoiding abrupt termination, notifying the patient in writing and giving the patient time to secure another provider. agreeing to continue seeing the patient until another provider is secured, and cooperating and sharing relevant information with a new provider. So you'll oftentimes see those things in those letters that a physician will say to a patient, or will send to a patient when they're releasing them from their care. Antitrust laws, I'm not going to get into that, but this is very interesting to read through. And these are federal antitrust statutes. So we'll just skim through those. Where does antitrust connect with healthcare? There are some activities that could lead to antitrust concerns. I don't know if I've shared with you before, but a good example would be if a hospital owns a nursing home and a patient needs nursing home care, they need to clearly indicate that they own that skilled nursing facility, and when they provide a list of skilled nursing facilities to the patient to choose from, the patient gets the choice. So for instance, I've worked for healthcare organizations who have owned not only hospitals but physician practices and nursing homes, and the utilization nursing staff, when they provided a list of nursing homes to the patient to choose from for their follow-up care and for their transfer, it had to list all nursing homes within a 50-mile radius of the hospital, and it had to indicate the ones that were owned by the hospital that they were currently receiving services in. That would be an example of how they were trying to be honest and not violate antitrust laws, and not try and steer patients to their care or be deceitful about how it financially benefited the organization if patients chose to go to those owned nursing facilities. So that's an example. But there are these areas where antitrust can come into it, and then you find yourself dealing with the feds, not with the state. The other things are the state. This is still antitrust. And it's just how they determine what is antitrust violation versus what is not. You can get into antitrust claims or issues if you deny medical staff privileges, restrict credentials, if it's found to be a group boycott, or if it is something that blocks free employment or free credentialing in the sense of everyone's included. So antitrust is really where someone is excluding people who have the right to practice, but antitrust is excluding them simply to limit competition and that sort of, and financial benefits. And that gets into economic credentialing, and you have to be really careful about that. You don't want to refuse credentialing to physicians just because they'll have a low volume of cases, or because they have ownership in a competing facility, that type of thing. That's called economic credentialing, and that will get you into antitrust hot water quickly. Then you have some other things that have come up that have limited the ability of physicians to invest in hospitals. So bottom line is medical staff privileging has to be fair, can't violate rights, can't favor certain individuals, can't restrain competition, and there has to be a fair hearing process. And this is just more information about that. All right, that's it for Chapter 7. I hope you have a rest of a fabulous week. And I will be back soon to talk to you about Week 5, where we go into Chapter 8, which is Consent to Treat.